Welcome back to the next session at our SQE conference, and this session is going to cover the assessment specifications and functioning legal knowledge. Now, no SQE session is complete without a different or new acronym, so we'll probably be using FLK, which will stand for functioning legal knowledge, quite a lot throughout this session, so just to be aware of that. In this session, we'll be looking at a high level what SQE1 and SQE2 covers, the key information you'll need, and our approach to how we might publish further information on the content of the assessment. And already, I think in previous sessions, we've had quite a few questions asking around will there be any more detail? How will you publish further information? So we'll be picking that up in this session. There'll also be some time at the end for questions, so please submit them on the link below. And there is also going to be a poll later in the session, which we'll introduce, and we'll be looking for your input, so get ready for that. So on to our speakers. So first up, we have Jill Foster-Taylor, who is Interim SQE Academic Director at Kaplan. Her background is as a solicitor in commercial practice. She's also taught at Nottingham Law School and as course leader for the LPC and GDL at Kaplan Law School. She's been at Kaplan since 2012, working on the academic delivery of the QLTS, that's the Qualified Lawyers Transfer Scheme, and now the SQE. She's part of the senior team responsible for delivering the SQE assessment specifications and sample questions, as well as some of the processes and policies around the two SQE pilots. Now, our other speaker is Julie Brannan, who I've already introduced earlier today, but she's our Director of Education Training at the SRA. And she was obviously so dismayed how I was chairing the event. She's going to take over and asking a number of the questions in this session, and then I'll come back at the end. So, Julie, I'll hand over to you to do a better job than me.
I'm sure not, Ben, but thank you very much indeed, and hello again, everybody. What we wanted to do in this session is talk about the content of the assessment and how it's described through the assessment specifications that we have published, and how perhaps people who are looking at those assessment specifications with a view to preparing training courses might want to approach them, read them, and understand what they mean. So I've got some questions, and which I'm going to ask Jill as the expert around all of this. And to kick off, Jill, first, very general question, what advice can you offer stakeholders when they look at the assessment specifications in terms of how to approach reading them?
Hello, Julie. Yes, so the first piece of advice is to read the assessment specifications holistically. That's to say, it's very easy if you're interested in a particular topic in the law to pull that topic out of the functioning legal knowledge, have a look at it, wonder what it means, and so on. But actually, it's really important to read it as a part of the whole assessment specification and to see how it fits into the information that's provided in the specification. So for SQE1, because there are separate assessment specifications for each of SQE1 and SQE2, both published now. So for SQE1, you need to consider the FLK within the context of the assessment objectives for the relevant area of law, and read all of the preliminary sections in the assessment specification, which deal with the level, what we mean by knowledge and application, what the subject matter dealt with is, and so on. And similarly, for SQE2, again, you need to consider the FLK within the context of the overview provided. The assessment objectives and assessment criteria are there, and then preliminary sections talking about skills or skills and law, marking, and so on. And I might just add, whilst we're talking about the assessment specifications generally, that the FLK provided in the SQE1 assessment specification is missing some parts when you come to look at the SQE2 assessment specification. That's to say, the SQE2 FLK, sorry about this, is a subset of the SQE1 FLK. Not all of the topics examined at SQE1 are examined at SQE2.
Yeah. So we'll come on to in a moment just to look at in a bit more detail what's tested in each of SQE1 and SQE2. But I think that for me is really very, very important that in each case we're looking at some legal knowledge and legal skills that are assessed through both of those assessments. But actually it's the context in the assessment specification which particularly sets out what the assessment objectives are, which gives guidance to what it is that we're asking candidates to be able to demonstrate to us. So what it is that we want to see that they can do with their knowledge or their skills that we're testing through the through the SQE. So it's really important to read all of that together. But just moving on then to what's tested in SQE1, are you able to just expand on that notion at a sort of high level? What is it that we are trying we're fundamentally asking somebody to be able to demonstrate to us that they can do through SQE1?
Yes, okay. So SQE1 is testing the application of fundamental legal rules and principles at the level required of a competent day one solicitor. So a newly qualified solicitor on day one of practice. So we're not looking at specialist practice. We're looking at the level of the just competent newly qualified solicitor.
And so I guess a couple of things about that. It's quite interesting for people coming from an LPC background, whereas of course the LPC was assessed at day one of a training contract. SQE is assessed at day one of qualification, day one of a qualified solicitor. So I think that's an important aspect for people to pick up on. And in terms of that distinction, Jill, that you say it's the level required of a competent newly qualified solicitor, but it's not the level required for specialist practice. Can you tease out a bit for people what the difference is there?
Yes, so we're talking about mainstream rules and principles. We're talking about the ability of the candidate to apply knowledge which the day one solicitor would carry in their head. There are no resources or materials available in the SQE exams other than what's provided in the assessment papers. So it's not a question of testing matters of detail which a day one solicitor would have to look up. We're talking about straightforward transactions and performance at level 3 of the threshold standard, the SRA's threshold standard, so that the day one solicitor can properly identify relevant basic legal principles within an appropriate area of practice and apply the law effectively in an individual situation. Some of the questions will be set in the context of transactions, and those will be appropriate and straightforward as a day one solicitor would be asked to address. And I ought to say, I suppose, that the questions themselves are written by solicitors with experience of that day one level. So the newly qualified solicitor who is just competent is the level at which we're testing. So then there's no question of trying to catch candidates out. We're not trying to make things complicated for the training providers. We're testing main rules. We're not looking at obscure exceptions to rules. And actually, you and I talked about this a bit earlier in the year, Julie. January seems an absolute lifetime ago for all sorts of reasons. Yes. But in January, in the webinar where we met to discuss the sample questions for SQE1 that had just been released, we talked about a few examples of questions, and I thought it might be helpful just to briefly go through a couple of those to illustrate.
That would be really helpful, Jill. Yes, please. Yeah, could you pick those up? Yeah.
Okay, so one example was a question which set the scene with a client coming to ask a solicitor about their neighbour's roof which had fallen into disrepair. And the information in the question told the candidate that the client and the neighbour had entered into a deed recording a covenant where the neighbour had promised not to let their roof fall into disrepair, and now the roof was in a state of disrepair, and the client wants to know whether they can enforce that covenant against the neighbour. Now, there was a certain amount of discussion sort of on social media about what was being asked in that question. There were various issues being raised about whether there was the passing of the burden and the benefit of the covenant and so on, and all sorts of things that the question might be testing. And we were really keen that the point be understood that the information that was required to answer the question was in the question. The question explained that the client and the neighbour had entered into a deed of covenant. Therefore, they were the original contracting parties. They were the original parties who had agreed that covenant. And therefore, whilst there is law surrounding positive and negative covenants and the passing of burden and benefit and all the rest of it, and all sorts of things which we might choose to test, that question was not testing those things. And had it been testing any of those things, it would have been very clear from the information given in the question that that was what was being asked. So for that question, it was a straightforward test of, do you understand about the enforceability of covenants in this case recorded in a deed? And so it's a very useful point that I think that whilst you look through the answer options, all kinds of possibilities might go through your head. You have to focus on the information that you've been given and understand that you work only with the information that you've been given, and that you don't have to invent extra information to go into the question in order to find the right answer.
Yep. I think that's really, really important for people to be aware of. So the candidates don't need to make up information or make assumptions about information which is not included in the question in order to reach the right answer. And actually, if they are doing that, they're probably going down the wrong path. And I think you've got another example actually that we discussed in that webinar back in January, Jill, as well, which is about a Privy Council precedent decision.
Yes, again, so a question about the status of a decision of the Judicial Committee of the Privy Council as a precedent, and the question itself is set in the context of the Court of Appeal, looking at this decision from the Privy Council and needing to know what the precedent status of that decision is. There we were testing the mainstream position, the regular position, how are decisions of the Privy Council viewed in the context of decisions made within the court hierarchy. And the answer is that whilst they must be viewed as persuasive and may well be highly persuasive, they are not, as a matter of normal law, binding precedents on the court hierarchy. However, there is a situation where there's a limited departure from that position allowed, and there has to be a special direction given by the Privy Council in relation to that specific decision. And I suppose that might be something that we test, although it doesn't seem to fit the description of mainstream well. But we weren't testing that point, and it would have been very clear from the question if we'd been looking at a direction having been given by the Privy Council. So again, the question was focusing on the mainstream position, the standard position of the status of a decision of the Privy Council in relation to the doctrine of precedent.
Yeah, so again, a really neat example of somewhere where if that rule had applied, there would have had to have been another fact set out in the question which was not there. So candidates don't need to make up that fact in order to reach the an answer. And if they're doing that, they're going down the wrong track. So I think that's really helpful, Jill. Thank you very much, both in terms of how to read a question in the question paper, but also that's the emphasis that you've just given on questions really being focused on the main rules, not on anomalies or exceptions to the main rules. So there's some guidance for people for SQE1. What about SQE2? Can we turn to that and look at what's tested in SQE2 and how that works?
SQE2, again, is a test of mainstream and not specialist practice. So in SQE2, we're testing legal skills within the context of fundamental legal rules and principles, again, at the level of the competent, newly qualified solicitor. The SQE assessments involve relatively straightforward tasks. and those mainstream issues will be picked up within the tasks in the context of transactions or cases which the day one solicitor might meet. And again, the threshold standard, level 3, is appropriate here. That's the level at which the candidates are being tested. So we're looking at what an individual ought to be able to perform on qualification as a solicitor, demonstrating legal knowledge and the application of that legal knowledge and reasoning in the context of the transaction or the case. And so you would expect there to be some legal training that lies behind the ability of the candidate to perform in that way.
Yes, I guess training and experience and exposure to the way solicitors in the office use their skills can all help prepare people for SQE2. So if we can just move on to another question, which we do get asked quite a lot, and I think a question came through this morning, one of the earlier sessions, and we saved it up for this slot. It was a question about the level of detail in the assessment specifications, particularly in relation to functioning legal knowledge, and whether more detail would be provided, whether more detail should be provided. And I think people, you and I have both heard people say, Jill, that training providers would like to see more detail so they can be sure that they are teaching to the right level of detail as is assessed in the SQE assessment itself. What's your answer to the question about why the FLK is not set out at a greater level of detail in the assessment specifications?
I think it's quite useful to look at where the assessment specifications came from to answer this question. So way back, long before Kaplan was a twinkle in the SRA's eye, the SRA set to work on developing the SQE. And did a huge consultation exercise, as I understand it, and then on the back of that appointed appropriately qualified solicitors to consult and advise on how the FLK should look, because there was this idea that the functioning legal knowledge should form a part of the assessment specification for the SQE. And so there was a huge amount of work that went into developing the FLK, pitching it at the appropriate level for this sort of a licensing exam and so on. And when Kaplan was appointed, we inherited the 2017 version of the assessment specification, which already contained a version of the FLK, the functioning legal knowledge. And it was part of Kaplan's task in the early months following appointment to review the assessment specification, to develop it as required. But the SRA had already done the work that I've described in getting the FLK into shape, and so it wasn't the task of Kaplan to rewrite the assessment specification or to redevelop the FLK. There was some work done on it. We did notice that across the board there were some subjects which seemed to be weighted a bit more heavily than others. There seemed to be some subjects which were on which there was more detail provided than others. So we did some work on leveling the detail, and we similarly had a team of qualified solicitors who were appropriately experienced in teaching, in practice, to understand the level of the day one solicitor. And we made some adjustments to the FLK, and then that was what eventually went into the SQE1 assessment specification and was published. I think it's right to say that it wouldn't be helpful to specify the FLK in minute detail. The more levels of detail you provide, the more questions arise as to how it works and so on. And it's really important that we're able to rely on the expertise of the training providers in developing courses that will test candidates appropriately in line with the provisions of the assessment specifications.
I think that's right, Jill, and my recollection of that exercise that we went through, where we got subject matter experts who were also solicitors to look at the content of the FLKs, one of the questions that we explored with them was, did that give them enough of a steer? I think they were all involved in professional legal education, about what was encompassed within the SQE, and did that give them enough guidance about what to teach to prepare somebody for the assessment. And that was one of the considerations we went through very carefully with them, and the guidance that we got back from them, subject to making various tweaks that we picked up at that point, was that did give a training provider enough information so that, using their own expertise, they could interpret the assessment specification and understand what would be assessed within the topics as described in the assessment specifications. So we did, my recollection is we looked at that really quite carefully. I mean, I guess despite having very consciously sought to address that in our development work, it's of course possible that stakeholders may still remain uncertain about whether a topic is in fact covered by the assessment specification or not, and whether as a training provider they need to teach it, or as a candidate they need to learn it. And I don't know whether you've got any additional guidance or tips for somebody in that position.
Well, I'd go back to what I said at the start. About how to use the assessment specifications and how to read the assessment specifications. So looking carefully at the assessment objectives and reading the various sections of the FLK in the context of the information that's there. And to remember always that questions are designed to test application of fundamental rules and principles. I think it may be useful to know that for question writers appointed by us, the first step is to have the appropriate section of the FLK and the information from the assessment specification, and for question writers to be asked to write squarely to the FLK. So they're writing questions which are at the appropriate level, and if they write questions which aren't squarely within the FLK, if there's a question about whether something sits within the FLK or not, then that isn't a question that would be used. But actually the instructions to writers as they write is to write to the FLK and to write at the level of the day one just competent solicitor. And the same is true of question editors, that as question editors work through, they're always asking themselves the question, where does this sit in relation to the FLK? Is it clear that this is a mainstream issue to test within the information that's available in the FLK? I don't know how much more you want me to say about that.
Well, what I was just going to pick up then, for me, what was really important, and just to reinforce in what you said, is that question that your question writers are always going to be asking themselves, am I confident that this question is clearly covered by the FLK? So I think that again is something that training providers can pick up. So what we're saying, I guess, is that the assessment specification is there to help people. It describes, if you like, the curriculum assessed, and therefore it helps training providers understand what they need to teach and what candidates need to study. But we do expect that training providers will use their expertise to define the detail. I guess, pushing you a bit further on this, Jill, people might still be uncertain. They might say, well, yes, I've heard what Jill says about the level of the day one solicitor, and that it's got to be clearly within what's set out. Questions got to be clearly within what's set out in the FLK. But I still just don't know. If somebody's in that position, what should they do?
Yes, of course. Well, I think the answer is we'd like to hear from people who are still in a position of uncertainty. So stakeholders will appreciate and understand, I think, when I say that we can't correspond individually with candidates, training providers, firms, or whoever to explain individual aspects of the FLK or the assessment specification, and we wouldn't provide answers one by one without providing them to everybody. It's really important that if there is to be any more information in any respect, then everybody who has a stake in the SQE hears about it at once, at the same time and in the same way. So I think the approach should be that if there are outstanding questions, then they should be sent into the SRA, and the SRA will collate those questions, and that we intend to have an annual review process where questions brought forward by stakeholders will be considered, amongst other things. We can't be in a situation where individuals need to keep checking the assessment specification to see if it's different from before. We can't have frequently asked questions which are changing from week to week and people have to keep an eye on things. We must have some clarity and some stability about how the information is presented. And so that's the idea of having an annual review process where we will collect questions from anybody who has outstanding difficulties, and we'll address them all at the same time. And then if there is going to be information released, it will be released publicly and at the same time to everyone.
And actually, just on this point, and you mentioned the annual review, Jill, we've just had a question come in, which is absolutely relevant to this point, which is about whether the specifications will be regularly updated if laws or legal precedents change, and I guess also if that people feel that there's an error or something which needs to be corrected in them. Do you want to just pick up on those points?
Yeah, sure. So the agenda for the annual review will be to look at changes in the law and changes in practice too, to look at any areas where it's been suggested that clarification is needed, and to look at anything else by way of essential changes which may be needed. And clearly the annual review process will be one which hopes to capture everything which arises and needs addressing. It's got to be said that the FLK is deliberately pitched at a level where small changes in the law won't change the FLK. That's to say, year on year tax rates and thresholds change, case law supersedes earlier case law, and so on. But because candidates are not expected to cite specific cases, nor are they supposed to be familiar with individual section numbers, that the FLK can kind of ride above a lot of those changes, that the law can be a bit fluid underneath, and changes in the law wouldn't require changes to the FLK or to the assessment specification if something that affected the wording of that needed attention. But that will be the purpose of the annual review, to look at that situation, to see whether there is revision in wording that's needed, and in a situation where actually the FLK itself was out of date, that would be the opportunity to make the changes and to publicise the changes.
And of course, the other thing that can happen, we all know with law, is that it can change at any point, and we may be able to pick it up as part of the annual review process, but there may also be some fundamental change in the law that happens on the eve of the SQE. How do you propose to deal with those sorts of last minute changes in the law?
Okay, well there are a couple of things to say there. That there's one thing, just to go back to the annual review. We'd be very interested to hear from stakeholders when it would be helpful for the annual review itself to take place, because obviously stakeholders will be juggling all sorts of writing deadlines, print deadlines, course delivery deadlines. Candidates will have their own interests in when it's helpful for them to know, and so on. So any suggestions as to when the annual review would be best held and why, it would be very helpful to have those sent into the SRA. The point about last minute changes in the law raises another issue, which again we'd like to hear from stakeholders on, which is whether it's preferable to examine the law at the date of the exam, which is one option, or to consider whether we should introduce a cut-off date and make it clear that the last minute changes to the law wouldn't be examined because the law will be frozen at a fixed point a certain time period before the exam, so be that 2 months or whatever. And again, that's something that we'd really like to collect views on, because at the moment and in QRTS, we're able to examine the law at the date the exam itself, and that works for us. But that isn't necessarily what will suit the number of people preparing for the SQE. So I suppose I'm handing over to Ben, I think, to talk a little bit about the poll now.
That's right. Yes. So Ben mentioned at the beginning of the session that we would have a poll for you, and this is what we wanted to ask your views on today, which is, do you think that we should examine the law on the date of the examination, or should there be a prior cut-off date after which we will not take into account any change in the law? But Ben, as Jill says, over to you.
Yeah, so what you should see is there is a link below this broadcast which you can click on, and you can submit your views on that. There were some eager beavers who were already completed that poll before the session had got going, so thank you to those people. Actually, this poll is going to be open for a month, so we appreciate we're not expecting a firing from the hip quick fire answer. If you don't want to give one and you want to go off and think about it, that poll will be open for a month, but we really do want to hear people's views. So you can let us know now and we can have a look at that, or you can let us know over the next few weeks, and then we at the SRA and Kaplan can take that into account before we make a final decision. So if you want to click into that poll, but I think that brings us to the end of sort of that slot with Jill and Julie, and we've had some pre-submitted questions and also some questions that have come in, so let me just run through these. So I think the first question, perhaps I'll come to you on this one, Julie, is we have a question about a day one solicitor level, and somebody saying today's solicitors specialise as they do their LPC. So if SQE day one isn't about sort of specialist knowledge and it's about general knowledge, is the SQE going to produce a generation of generalists? How many generals can I get into a question?
So we, as everybody knows, the solicitor qualification is a very broad one. There are certain reserved activities that are activities that you can only, legal activities you can only undertake if you are an admitted solicitor. Those are the activities, if you like, that we license individuals to undertake when we admit them as solicitors, and where we have a particular responsibility to members of the public to assure the competence of solicitors in relation to. So the SQE is very deliberately and consciously constructed around those reserved activities. So that's why you see civil litigation, criminal litigation, property law, probate as really the heart of the SQE, and the only extra element we've added in there is business law and practice, because it's such a wide and fundamentally important aspect of solicitors' practice. So that's why the SQE as it is, and is a generalist qualification, exactly as the person who raised the question says. It's because it's aligned round those activities that we are authorising people to practice in, where other members of the public, which other members of the public can't practice.
Would it be worth adding, and I suppose we might come into this in a later session, but Finn in one of the previous sessions covered that actually, although they'll be preparing people in terms of the context of the SQE, they're planning on doing training around tech and the like. Yeah. And one of the big differences on the, not just looking beyond the SQE assessment, is a more flexible approach to qualifying work experience should allow firms to, rather than sort of prescriptive seats and what they need to do as part of the training contract, maybe to tailor their training more to the needs of their business in conversation with the trainees. So I suppose, although you might get generalists for the SQE, you might actually enable firms to have more bespoke training as well. Would that be fair, or am I off beam?
Yes, no, I don't think you're off beam. A couple of things on that. First of all, yes, firms can choose where to set their qualifying work experience, and they can align that with the needs of the businesses. The skills that we are assessing through SQE2 are very fundamental skills, an ability to communicate with a client, an ability to produce a piece of legal writing, and an ability to produce a legal argument. Those are very fundamental and generic skills. We've set them in the context of the reserved activities because those are the reserved activities. But anybody who is working in legal services will be developing those skills anyway. So the trick, I think, around qualifying work experience is really to focus on the competencies, the generic competencies that you're developing through exposure to working in particular practice contexts, rather than just focusing on the acquisition of the law, if you like, as it relates to those particular practice contexts.
Thank you, Julie. And Jill, perhaps I'll come to you. A question we've had come in around professors and tutors getting practical knowledge in relation to the assessment. Sort of how can they do that? And this person's asked, can they attend the examinations to see how it all works?
Yes, no, we can't have the assessments with people inspecting and viewing and wandering around. I don't think that would be a proper way of running the assessments at all. We will be in the course of next year inviting applications for individuals to become involved as SQE examiners, and there are all sorts of roles within the examiner role. So that would be a way of finding out more about the SQE, and we'd welcome applications from as broad a spectrum of individuals as possible, really. I think there have been some questions around specific guidance for how the assessments are going to look and so on, and I think it's really important, particularly in the context of SQE2, that people look at the assessment specification and read the information that's been provided and read the sample questions that have been provided as well, and understand that there isn't, as far as an assessment on SQE2 goes, there isn't a recipe for acceptable performance, that individual candidates are marked against the assessment criteria, and that if we start offering examples of how to do it well, video recordings or whatever, there's a huge danger that people will feel that they have to copy what we've done in an individual performance, whereas actually, as stakeholders will understand, there are a huge variety of ways of demonstrating that you are a competent, newly qualified solicitor. There isn't a recipe as to exact words that you have to use, but the assessment criteria provide the guidance that's necessary as to how to indicate your competence.
Thank you, Jill. And a couple more questions we've had come in. Perhaps this is one for you, Julie. Somebody's asked, what is the material that must be covered to assist students studying in this area? Will there be, can we recommend books that people should be buying and the like? What's the answer there?
Sorry, Ben, you're just going to have to repeat that question to me again, because I was looking at another question that's come in. Sorry, go on.
That's okay. Well, I know you'll be well prepared for the next question. So the question I asked was around, will we be recommending books which people must be purchasing or studying? Will there be sort of set materials that people need to read beyond the assessment specification and sample questions?
Yeah. So thanks. Yes. So no, as I hope people know, we are regulating, if you like, SQE by regulating the assessment itself. That gives us the assurance that people have met the standards that we require for people to be admitted as a solicitor. We are not recommending particular textbooks any more than we would recommend particular training providers. That would not be appropriate. We want to have an open and competitive market. We know that there are different ways of training that suit different people's needs, and we welcome that degree of flexibility in the market that gives people choice as to how they might want to prepare for the assessment.
And building on that, Julie, we've had another question that has come in that, so I'm just trying to pull it up here, that effectively asks, well, is the SQE fully developed and tested? Is this still an exam still in progress? And I suppose then, is that fair for the first round of SQE1 candidates? Yeah.
So that's right. So all exams have to run for the first time at some point. That's inescapable. But what I would say in relation to the SQE is that we have just spent 2 years developing it. So we have, as everybody knows, in the session this morning, we talked about the fact that both parts of the SQE have been properly piloted. We've refined the approach in the light of the pilots, and we have designed the assessments not just in the light of our learnings from those pilots, but also, as Jeff Coombe, independent reviewer, said this morning, in the light of experience in other assessments and in the light of expertise and the literature. And the other thing that I would say is that, of course, at the high level, SQE is not identical to QLTS, but it's similar. And of course, Kaplan have, what is it, Jill, about 10 years of experience of running QLTS. So at a high level, running a computer-based single best answer assessment, running skills exercises like SQE2, that is very familiar already to Kaplan.
Yes, thank you for that. I'm just looking at time, and we're nearly up. I'm just looking at one of the other questions that's come in. There is a question, and I don't know whether, Jill, you can answer this or whether it's one we need to take away, is around the SQE marking. Will that be subject to any external moderation or checking, or is that something that's done entirely sort of within Kaplan?
There'll be more information provided in relation to marking and standard setting and so on, but it's not available yet, is all I can say as far as
Yeah, and I think in our information strategy, there's a marking and standard setting policy, which I think off the top of my head might be March next year, but I have to go off and check that. So there'll be more details in there.
And what can I just add into that, of course, SQE1 is marked automatically, so it's a slightly different approach for SQE2. Of course, there are quality assurance processes built into all of this, so there's quality assurance processes within Kaplan. We at the SRA are the external quality assurance agency organisation for apprenticeship purposes, which really, if you like, overlaps our role in relation to non-apprentices as well. So there are tiers of quality assurance which check the quality of the marking and the moderation as we go through the both processes, both for SQE1 and SQE2.
And then I suppose beyond that, we heard from Jeff earlier as the independent reviewer, who will be doing an annual report on sort of how the whole assessment ran. Well, I think we've just come up to time, and I think we've managed to cover most of the questions that that came in. I've got a sort of snapshot reading of where we've ended up on the poll, and it's very much a live poll, and as I say, it's open for several weeks. There seems to be a broader preference towards the cut-off date not being the day of the exam, so to speak, and being a date earlier. We'll be really interested to look at your comments there and what your suggestions are around what that appropriate date might be. And as I say, that will go into the mix with all our stakeholder engagement before we make a final decision on that. But otherwise, I wanted to say a big thank you to Jill and Julie for that conversation, and hopefully that's been very useful for people in understanding a bit more about the assessment itself. Apologies for the flicker on Jill's screen. I've been up on her roof fiddling with the aerial, but it hasn't quite worked. But I think the content of that session I found really, really helpful. So I hope you did too. Again, this is where I flag up, there's an evaluation link at the bottom of this. If this is your last session, maybe you could click on that and let us know how you found the sessions you've attended, and including this session. The next session we've got coming up is going to start at 2:20. That is on monitoring and maximising diversity in the profession, and I very much hope you can join us for that. But otherwise, thanks again to Jill and Julie, and I'm going to try and grab a sandwich now to see how quickly I can eat that before the next session. Thank you very much.
Thank you very much. Bye, everybody.
Bye-bye.